it's wonderful to be here. And when Mark welcomed me back, he might have been referring to the time we were here with Thanksgiving thank yous or the grant money we got for an emergency vehicle. What you probably weren't referring to is the number of times I've been in this very emergency room with one of my children, or 12 years ago, a little over 12 years ago, when I myself gave birth here at this hospital to my youngest daughter, who, while I say we're from Montclair, she says she's from Livingston because she was born here. So she's always a little contrarian. It's wonderful to be here this morning, but it's not so wonderful to be talking about the truly important issue that we're talking about. Because I think we're all very concerned about the continued rollback of the protections that women across the country are facing. So good morning. Thank you so much to everyone for joining us. Thank you to President Manigan, to Dr. Pawar for lending your voices to this important event. I truly appreciate it. There couldn't be a better backdrop here as we talk about how important this emergency care, this service is to people across the country, because today the Supreme Court is going to hear oral arguments in the cases of Idaho versus the United States and Moyle versus the United States, cases that could outlaw access to emergency care for women who are having a miscarriage or having a dangerous pregnancy, outlaw that emergency abortion care in many states across the country. It's why I'm standing here today with New Jersey healthcare providers to underscore what's at risk and why emergency abortion care saves life. But first, it's important to understand how we got here. In anticipation of the Supreme Court overturning Roe versus Wade, the Idaho state legislature passed one of the most restrictive abortion bans in the entire country. These were called trigger laws. They would be triggered when Roe was overturned. It even includes steep criminal and civil penalties for anyone who provides an abortion outside of 3 incredibly narrowly defined circumstances, including no less than 2 years of prison for an abortion deemed criminal. That's why the Department of Justice sued Idaho for violating federal law. That law is the Emergency Medical Treatment and Labor Act, which guarantees that in an emergency, patients will receive the life-saving care they need. That includes abortion. And what these Idaho lawmakers fail to understand is that when a woman comes into an emergency room with complications regarding her pregnancy, whether it's a miscarriage, an ectopic pregnancy, or anything else, often the life-saving medical treatment they need at that moment is an abortion. So when I was here 12 years ago, I knew I would get that kind of care if I faced one of these medical complications. Too many women across the country will not know that in the future if EMTALA is overturned. Now, if the Supreme Court decides that this federal law cannot preempt state abortion bans, there's no federal guarantee that women living under these draconian laws will receive the medical care they need in an emergency. And doctors in those states, much like those here with us today, will be criminalized for just trying to save a life. Imagine, as a doctor, making that horrible choice. It's not just hypothetical. These restrictive laws are destroying access to maternal health care at a time when we're seeing deeply concerning increases in maternal mortality across the country. 2024, increases in maternal mortality. Even before Roe was overturned, between 2019 and 2021, Idaho's maternal mortality rate doubled, and since they banned abortion care, OBGYNs are leaving the state at a rapid rate. Idaho has lost more than half of its maternal fetal medicine specialists who address high-risk pregnancies. 3 rural hospitals have shut down maternity services, and 13 of the state's 44 counties are considered maternity deserts. In other states across the country post-Roe, we're seeing horrifying reports of what happens when women's access to reproductive health care is denied. In Texas, a woman miscarried in the lobby restroom of a hospital as front desk staff refused to check her in and her husband called 911. In Florida, in a Florida hospital, a woman learned that her fetus had no heartbeat the day after a security guard turned her away from the triage area for bringing a child with her. In North Carolina, a woman gave birth in a car after an emergency room couldn't offer her an ultrasound, and the baby didn't survive. These stories are gut-wrenching and all too common in the post-Roe era. And as a Navy veteran, I know that there are service women who are being stationed in these states and have no choice but to follow those orders to go to states that will have no care for women. And if they or someone in their family ends up at a civilian hospital with a pregnancy-related medical emergency, they deserve more than to become another one of these historic stories, horrific stories. That's why, along with other congressional Democrats, I signed on to a brief urging the court to uphold the federal law that guarantees this right to life-saving care everywhere. It's simple. Politicians, legislators should not be deciding whether pregnant women live or die. In fact, we can and should be doing more to improve women's health and maternal health, not undercutting the basic reproductive freedoms and access to life-saving care. That's why we have to be ready if the Supreme Court further chips away at women's reproductive freedom. In New Jersey, we have important laws in place that fiercely protect reproductive freedom and health and ensure that the doctors at our great hospitals can live up to the Hippocratic Oath without fear of legal persecution. But this Supreme Court case would eliminate those federal protections for doctors in states with abortion bans to provide a necessary abortion care. So we have to be prepared and vigilant to support women's freedom and livelihood and to support doctors so they can provide life-saving emergency care when patients need it. So with that, we're happy to take a few on-topic questions if you guys want to join me.
Well, if the Supreme Court finds in favor of Idaho, what do you think Congress should do?
So I think Congress will have to take a look at how we can legislate in light of the Supreme Court decision. Sometimes it's the details of the decision and how the court finds. I think what the court may find is that EMTALA is simply an assurance that women can't be turned away from the care a hospital gives, not the actual emergency protections that EMTALA provides. So if that is the case, then we should pass a new statute delineating that, in fact, Emergency Medical Treatment and Labor Act actually does support providing life-saving care to women in these cases, but a lot of this will be in the details of the Supreme Court finding.
Would it be realistic to believe that something like that would get out of the Senate even if Democrats retain a slim majority?
I would hope, and I can't promise anything, but I would hope that in this country, our legislature can provide basic emergency protections to women, that they can see women as actually a group to be protected in basic emergency situations, that the life of a woman should be important enough to people in this country that they deserve emergency medical room treatment if their life is at stake or if their health is at stake. Okay, thank you.